thank you everyone for joining our webinar here today. As always, this webinar is presented by Tag Inspector. And today we'll be discussing tag governance and specifically optimizing data collection in today's privacy environment. First, quick call out, a few upcoming webinars and events. So today we have this webinar, obviously optimizing data collection in today's privacy environment. It's in US time zones, and we're going to be focusing a little bit more on, or taking a little bit more time on some of the US legislation, specifically the California Consumer Privacy Act and what those implications are. On Thursday in the morning at European time, we'll be having a very similar webinar, optimizing data collection in today's privacy environments in the EU, where we'll be spending a little bit more time. I mean, we're going to go through GDPR and e-privacy directives and stuff like that today. We'll be taking a little bit more time on those topics on Thursday. And then next week, Tag Inspector has a new UI refresh. So for anyone that is Tag Inspector users or interested in the product, we'll be going through an in-depth walkthrough of the new UI, as well as some new functionalities. Over on the InfoTrust side, if you are in the States, we are doing an InfoTrust Analytics Roadshow. You can see there the cities and dates for those upcoming events. If you're around, we'd love to meet you, chat a little bit further about analytics, and check out the website in order to register for those different roadshow events. So moving on from that, today we'll be going through this topic, just a little bit of high-level information about myself, as well as Tag Inspector. So Tag Inspector, it's a product of InfoTrust. We do web analytics, tag management, product development work on the InfoTrust side of the house. And then with Tag Inspector, obviously it's a tag auditing and monitoring platform. So working with organizations on tag auditing, understanding what platforms are loading, what data is collected, what compliant data collection looks like, as well as what solid data collection architecture, tag architecture looks like. So work with thousands of websites annually. We put on a number of training events throughout the year, including this webinar here today. Quick disclaimer, just because we are going through privacy legislation and the implications on tagging, analytics, marketing, just the standard disclaimer, I'm not an attorney. We'll be going through some of the best practices and things that we see in the industry, and also interpretations of those legislations and how they relate to you, marketing and advertising professionals. But at the end of the day, for any of your company-specific policies and processes, it's always best and really a requirement for that to be finalized and approved by your own internal teams. Perfect. So with that, we can get right into it. So today, as mentioned, we're going to go through just optimizing data collection within the privacy environment. A big portion of this is going to be spent on really understanding and helping you hopefully understand better what that privacy environment is. So we'll be going through a few different acts as well as initiatives, what they say, what they mean, and then how it's applicable to your tag governance strategy. So really four main things that we'll be touching on today. First, the California Consumer Privacy Act. That goes into effect technically January 1st, 2020, and then enforcement will begin on July 1st, 2020. One of the requirements of that, though, that we'll touch on is that when a user is requesting what personal information you've collected on them, how it's been used, who it's been shared with, all that, there's a 12-month look-back window on that is a requirement to provide. So you need to be able to provide the personal information and all those specifics that, again, we'll delve into a little bit deeper for the previous 12 months. So while enforcement technically goes into effect July 1st, 2020, if on July 2nd, 2020, someone submits a request for that information, you're going to need to have that. You're going to need to know that for the past 12 months. So it's best to get ahead of the curve, get your auditing done, do your data mapping, and really understand what your approach as an organization is going to be for that. And hopefully we can help with that here today. Second thing we'll be discussing is the General Data Protection Regulation, so GDPR, as many people have, I'm sure, and should be aware. That went into effect last year, May 25th in the EU. So if you have any website visitors or consumers on your websites, or your organization has websites in the EU, that's going to be extremely relevant. There's also in the EU e-privacy directives, or what are more commonly known as cookie laws. Those are going to be country specific, but again, if your organization is global or you have websites that are focused in the EU, those are going to come into play. Those are currently in effect. And then finally, we'll touch at the end on some of the implications of some of the different technology initiatives. So some of you may be aware, Apple has their intelligent tracking prevention initiative that has some versions of that have already been rolled out within Safari browsers for both desktop as well as mobile, and some additional versions and implications are being rolled out here soon that are currently in beta, that are going to have some implications. So we'll touch on those, what they mean, how to address them, and some strategies to really think about as it relates to how technology itself is starting to combat privacy issues and really adhere to the privacy rights and requests of the various different users. As far as an agenda, we'll start out with those different privacy acts and regulations. We'll start with the California law, get into GDPR a little bit, e-privacy directives a little bit. For both of those, again, just because the U.S. audience here with just the time of the webinar today, we're going to focus more on the California Consumer Privacy Act and the things that are specific to the U.S. Once we go through each of those, hopefully get a good understanding, a good grasp of what's going to be necessary as a result of each of those different privacy legislation. We'll then go through requirements for your business, what it means, what you should be doing immediately to be able to really prepare your organization to collect data in a compliant manner. We'll then talk a little bit about optimizing compliant data collection, so how you can really improve and maximize the compliant data collection that is happening across your different web properties. Finally, we'll touch on those ITP considerations, and then at the end, we'll have a summary and a Q&A. As always, though, if you have any questions that come up as we're going through the content, I'd love for these to be a little bit more of like a two-way conversation. So if you have questions that come up, feel free to drop them into the questions pane that should be there on your GoToWebinar control panel, and I'll try to answer those as we go along. But anything that's left over, or if I don't get to it, cover it at the end. Perfect. So to really dive in, getting started here, touching on the California Consumer Privacy Act. As many of you hopefully know, this is legislation that goes into effect the next year, was passed the last year, and will apply to residents of the state of California. So what this does at its core, it's affording 5 key privacy rights to Californians. The first one is the right of Californians to know what personal information is being collected about them, have that be transparent. Second one is the right of Californians to know whether their personal information is sold or disclosed, and then if so, to whom, as well as the specifics of what is sold or disclosed. Third, the right of Californians to say no to the sale of personal information. So again, that's going to be opt-out requirements, as well as some conditions for opt-in requirements that we'll touch on. The fourth is the right of Californians to access their personal information. So they need to have visibility, and they need to be able to submit an access request, and you need to be able to provide them their information, any personal information, the categories of that information, to them upon request for the previous 12 months. Again, I'll probably hammer that home a few times on this webinar, just because it is super important to get started on this right away. Finally, the fifth is the right of Californians to equal service and price, even if they exercise their privacy rights. So just because someone says, no, you can't use my information this way, does not mean that they can be denied service or charged a higher price. So with the CCPA, who does it apply to? So any business doing business in the state of California that meets any of the following criteria. One quick call out, business doing business in the state of California. Basically, if you have any consumers that are California residents, that would constitute doing business in the state of California. It does not mean that you have to have a physical location there or any infrastructure there. So it's going to apply to any organization that meets one of these three criteria. The first is any company with annual gross revenues in excess of $25 million. Second one, any organization or business that annually buys, receives for commercial purposes, sells or shares personal information of 50,000 or more consumers, households, or devices. We'll get into some of those actual definitions for, like buys, sells, all that. And then finally, any business that derives 50% or more of annual revenues from selling consumers' personal information. So if you meet any of those three criteria, this privacy legislation is going to impact your business. You're going to need to adhere to it. If you meet those criteria, the law is then enforceable against any business that collects consumers' personal information, any business that collects personal information about a consumer or about consumers, sells consumers' personal information or disclose it for a business purpose, sell personal information about a consumer to a third party, as well as that just directly sell consumers' personal information to third parties. So if you meet those previous criteria or are engaging any of these activities, it's again going to apply to you. So a few important definitions here, and a lot of organizations when they first hear about this or read about it or see those enforcements, they're like, we don't sell that our users' information, especially if you're an advertiser. But the definitions here are extremely broad. So when it comes to collecting, buying, renting, gathering, obtaining, receiving any personal information pertaining to a consumer by any means, that includes, it's highlighted there, observing the consumer's behavior. If you're doing any kind of web analytics on your website, if you're tracking campaign performance on your website, you are observing consumers' behavior. As well as if you're doing any type of audience creation, pulling in third-party data sets, working with ad servers or ad networks, you would be obtaining and receiving information about users. Selling, it's a little bit more narrow. Selling, renting, releasing, disclosing, making available, all those things. Personal information about a user to another business or a third party, again, for monetary or other valuable consideration. One really important thing here is if you're collecting that information, publishing websites, if it's an ad-based revenue, you're collecting users' information and then you're selling that based upon their behavior, if it's targeted at all. So that's going to constitute that selling requirement there. We're talking a lot about personal information. So what is it? Any information that identifies, relates to, capable of being associated with a particular consumer or household. This includes, and it's specifically called out, internet activity, including browsing and search history, as well as web tracking data. So even if it's like a pseudo anonymous identifier, so like a client ID, for example, if you're using analytics, or if you have a unique anonymous identifier for users, again, for most analytics or advertising and marketing technology on your website, you are going to have that. So it can stitch sessions and views throughout a single session together. All of those things fall under this definition of personal information. Finally, a consumer is any natural person who is a resident of California. So this applies to residents of California, even if the activity is happening outside of the state. The only time that it would fall outside of the bounds of this would be if everything in the process happens outside of the state of California. But pretty much, if it's a resident of California accessing your website, it's going to apply. So those are really the key important definitions, and those words will be popping up quite a bit. The next thing that wanted to touch on here is the categories of personal information. So when it comes to disclosure, both within like your privacy notice as well as providing information that you've collected about a user back to them, the law really specifies that you need to be able to explain to them or tell them what categories of personal information have been collected. There's a number of different categories, but these 4 are the things that are going to be relevant for online marketing and advertising. These are the 4 different types of personal information that are going to be collected across like analytics or advertising tools. So the first one would fall under PII, just traditional PII, real name, alias, postal address. You shouldn't be collecting directly, at least from like a tag standpoint, any of these different things. It's possible email address could be being collected, as well as IP address, but those are more that traditional PII. The next category would be internet or other electronic network activity information. So this is like, browsing history, search history, consumers' interaction with an internet website. That's what a lot of, from a tag standpoint, when you're doing data mapping and trying to identify what platforms, what personal information is being collected, that's the bucket that most of that activity is going to fall into. Geolocation data, if you're collecting any of that, as well as inferences drawn from any of the information identified within any of the different categories. So if you're doing any kind of, even if it's just general profiling or extended audience creation, things like that, if you're making any types of conclusions or creating like lookalike audiences or preference-based audiences within an analytics tool that you're collecting data through a tag, this category would also be applicable. So what are the requirements? At this point, we've kind of established that pretty much any web activity, as long as you meet one of those initial 3 criteria, large enough organization, it's going to apply to you, and you're collecting personal information via the different tags, beacons, pixels on your website. So the first requirement related to those different rights afforded to the consumers is around transparency and disclosure. So there's a few different levels to this. At first, there is disclosure at or before the point of collection. So this needs to be, as soon as any of those tags execute, as soon as a user enters your website in which, marketing advertising technology is deployed, you're going to need to disclose to those users the categories of personal information that are being collected, purposes for which categories of personal information shall be used, and then notice of the collection of any additional categories after that initial disclosure. This oftentimes kind of best practice is going to be using a banner approach, similar to what you would have potentially seen on European websites or just websites in general across the globe that are complying with different types of cookie laws. So notifying the user that we are collecting this information, and then having them having access to all of those different categories, what the platforms are, how it's being used, why it's being used, all of that type of disclosure. You also need to beef up the privacy notice with some specific data points that are relating to the legislation. And this needs to be easy to find, easy to access for a user. So description of the consumer's rights to request information about personal information collected and sold. That gets back to those 5 rights that we had outlined earlier. So just disclosure to the consumer that you have these rights, we must comply. Description of consumers' rights not to be discriminated against for executing any of their privacy rights. So they need to be told that they can opt out without any penalty, basically. Disclosure of transfers to third parties. This is extremely important when it comes to tags on your website. Oftentimes, especially with media platforms that are doing cookie matching, things of that nature, the values that are being matched across those different platforms are being passed from your ad server, from your DMP to other ad networks. That would be transfer of that personal information, that anonymous, pseudo-anonymous identifier, to third parties. You need to understand what additional third-party activity is happening on the website, and be able to map that back to the tags that are initially collecting that information. And that all needs to be transparent and disclosed to the users of your website. Finally, you need to disclose that the consumer has the right of erasure. So they do have a right that if they request it, their personal information needs to be removed from any of those platforms that you control, as well as any of those third parties to which you have shared or transferred that information. Disclosures here must be in a form that is reasonably accessible to consumers and updated at least once every 12 months. Oftentimes, you're going to be updating this more frequently than every 12 months, just because, you know, the nature of tagging changes and different initiatives and different platforms being onboarded on your different web properties, you know, those requirements are just going to change naturally. In addition to the transparency and disclosure, the consumer also has a right to erasure and then also opt out. So when it comes to erasure, any personal information about the consumer which the business has collected from that, the consumer has the right to request that to be deleted. As mentioned before, this does extend to third parties with whom information has been disclosed as well. In addition to this, individuals have the right to opt out. So consumers must have an explicit choice and an opportunity to exercise the right to opt out before any selling occurs. They also have the right to opt out of any just collection, unless that collection, there are some exceptions to that, but namely, users just need to have the right or the ability to opt out of that tracking, that collection of personal information. There's also an additional level to this. Users between the age of 13 and 16 need to have the right to opt in as opposed to out. So you can't collect personal information about those users until they have opted in. And then users below the age of 13, that right to opt in lies with their guardians. Now, one, I guess, concern with this is, how do I know the actual age of an individual user? So it is specified businesses must have actual knowledge of the consumer's age in order for that provision to apply. So that means, if there is some sort of like a date of birth indication, maybe with an account sign up or something like that, if the consumer has indicated that their age falls within any of these ranges, that's when that right to opt in would apply. You cannot willfully disregard that, though. I mean, if it doesn't make sense for your website to have any type of an age selection, that's one thing. But if it does, based on the content or whatever it may be, businesses will be considered to have actual knowledge if you are willfully disregarding the user's ages. Finally, if you are selling any of that personal information, in order to be able to adhere to the opt-out, opt-in rights, it's explicitly stated you need to have a clear and conspicuous link on the home page, or basically the page that the user's on. Again, probably easiest to use a banner that is titled "Do Not Sell My Personal Information." So not the most aesthetically pleasing title to have on there. But again, if you are selling any of that information that's collected, that is going to be the requirement for that opt-out button. So those are the requirements, who it applies to, what those different implications are. Basically, consumers need to be notified. You need to understand what personal information is collected, by whom, for what purpose, where it's shared, if that data is, or if that information is being sold or transferred in any way. Consumers need to have transparent look and the ability to see that. And then if you are not complying with that, the penalties. So first one relates to state action. So the state of California, the Attorney General can file an action. And the fines for that are up to $2,500 per violation if it's an unintentional violation, and then up to $7,500 per violation if it is found to be an intentional violation. Per violation means per user. So say you have you have a third party on your website or a tag on your website that's collecting personal information, even if it is that pseudo-anonymous identifier. And say that's been collecting information over the course of 3 weeks. And in that time frame, you had, just to make it an easy number, say 100 visitors, something small. Each one of those 100 visitors would be a violation. Unique visitors, they would be a violation. So in that case, you would be looking at, for just 100 visitors, about a potential for a $250,000 violation. If it is an intentional violation, you'd be looking at around a $750,000 violation. So the scale for this, the scope for this can get massive. One note, if you are found to be in violation, you do have 30 days to correct that. It's not specific exactly what that correction means, but you do have the opportunity to go through that audit process and be able to rectify the situation and get around those different fines. In addition to the state actions, individuals are also granted the right to file a private action. And this can be a class action lawsuit. So it can be a number of individuals coming together. So if something like that is filed against an organization, obviously you have reputational damage, which we can't really measure, but also additional monetary penalties that could be incurred. Perfect. So that is the CCPA. It looks like a couple of questions. We'll go ahead and kind of jump into those before we move on to GDPR. First question here, will you get into how to manage the need to opt out of third parties as it relates to tags? That is a lot of downstream groups. So yeah, so in terms of the need to opt out, basically, you would need to have first visibility, just from your organizational standpoint, what tags are loading, what data is being collected. That would need to be transparent to the user, and then they would have the ability to opt out of those different categories of tracking. We'll get into how exactly to kind of go through that audit and manage that a little bit when we get to those requirements for your business. Another question around how agencies, development and media agencies, fall into the law. So technically it's on the organization, the business is the one at that point of collection that would be the ones that are collecting that data. Now, it could be argued that if you are piggybacking or loading in an additional third party within a, different media tags can act as containers. In that case, if it is unauthorized with the organization, you could be at fault in that type of a scenario. Perfect. So with that, we'll move into GDPR and just some of the requirements there. So when we talk about GDPR and some of those important definitions, first thing to really understand, the intent of the regulation was to instill basic privacy rights as human rights for all people within the EU. The punishments here for GDPR are large, up to 10 million euros or 2% of annual global turnover, whichever is higher, and that's for a violation, up to 20 million euros or 4% of annual global turnover, whichever is higher, and that is for basically like a willful disregard or the not correcting or not responding to a violation. Compensation claims for damages suffered by an individual. So again, individuals have the right to private action, and then, as mentioned before with the CCPA, reputation damage and loss of consumer trust, which in many cases, if you're all over the news, is going to be extremely detrimental. When considering fines, considerations will be taken into account, And one thing I always tell organizations that we're working with on this, it's important to remember, especially with GDPR, where it applies blanketly to everyone. It's important to remember that you're not the only one affected by the regulation. So as long as you can prove that you're taking the necessary steps and the necessary technical process considerations, you're going to be okay. You just need to make that true, conscious, concerted effort to adhere to the privacy rights here. A few important definitions, because it does vary a little bit from law to law, exactly what's considered, personal data and what's covered. So for GDPR, controller is one word that comes up quite a bit. So the controller is the organization or the individual that determines the purpose and the means of processing personal data. So oftentimes this is going to be, well, this would be like the website or the organization itself. And then you have processors who are responsible for processing personal data on behalf of a controller. This is where like agencies can come into play if they're doing processing. And processing is basically any access of personal data. So even if you're just downloading a report that has a data point that would fall under that definition of personal data, that would be processing. As well as if you're a third-party vendor or have technology that is collecting that information on behalf of a controller, you would fall into that processor definition. GDPR applies to all individuals, all organizations in the EU. It also applies to US organizations if you have EU visitors visiting your website. Those individuals still are protected and have privacy rights afforded to them under GDPR, even though you are outside of the European Union. Personal data is similar under GDPR as it is under the California Consumer Privacy Act. It's any information that can be used to directly or indirectly identify the identity of a natural person. Again, here, pseudonymized data can fall under the scope of GDPR, depending some upon the difficulty to attribute that pseudonym to a particular individual. If it is a unique anonymous identifier, again, such as like a client ID or a cookie ID that's associated with an individual, that does fall under that definition of personal data. Finally, we're going to talk about this more here in the next couple of slides, but processing is any operation performed on personal data or on sets of personal data. Again, as mentioned before, as a processor, processing is even just downloading a report with containing personal data. GDPR is really 6 key principles. Personal data should be processed lawfully, fairly, in a transparent manner, collected for a specified, explicit, and legitimate purpose. So it has to have a legal basis for that collection and processing. And any future actions taken with that data must also fall in line with those purposes set out. Personal data should be adequate, relevant, and limited to what is necessary in relation to the purposes for which they are processed. So if you have a business case for collecting information, all of the different personal data points that you are collecting must be the minimum that is necessary in order to perform that business activity. It needs to be accurate and where necessary kept up to date. Every reasonable step needs to be taken for inaccuracies to be erased or rectified. Basically, have clean data, collect good data, have a good data collection architecture, especially as it pertains to personal data. Personal data must be kept in a form which permits identification of data subjects for no longer than is necessary for the purposes. We see this a lot as an implication within analytics. You can't just hold on to data indefinitely. There has to be an endpoint, and it needs to be reasonable based upon, again, that business purpose or that purpose for which was defined at the initial collection point for why you're collecting that personal data. Finally, the 6th principle is that personal data must be processed in a manner that ensures appropriate security of personal data using appropriate technological and organizational measures. Data needs to be encrypted, stored securely behind firewalls, all of that. Any technical and operational safeguards, processes, procedures, Those need to be outlined, they need to be applied, and they need to be adhered to. For who is really responsible for this, and this is one key tenet for GDPR. Controllers shall be responsible for and be able to demonstrate compliance with the principles. It's on the business. There is no excuse that, oh, this processor was collecting this, I didn't know. You are ultimately responsible for personal data collection, processing. You need to know what's going on. You need to know who's using it, how it's being used, where it's being transferred, all of that. Another key here under GDPR is that you have to have a lawful basis for processing. It's one of those 6 principles. Your lawful basis for processing is that business use case that's set out, and it must be determined before processing. It must be absolutely necessary in order to be able to achieve your business objective or whatever it is, your reason for collecting personal data. The personal data point must be absolutely necessary in order to be able to carry out that action. Otherwise, it should not be collected. Your privacy notice must specify that lawful basis for collecting, and that applies to all the different platforms and all the different business cases. And ultimately, within the law, there are 6 different lawful bases available that can be used for processing. All 6 are listed there. For purposes of marketing and advertising, though, especially as it pertains to tags on your website, you're really just going to be working with either consent or legitimate interest. And we'll talk about each in a little bit more depth. So first one that you could be using as your lawful basis for processing is consent. Under GDPR, any freely given, specific, informed, and unambiguous indication. So it clarifies that the indication must be unambiguous and provide a clear affirmative action. There is no implied consent for the collection and processing of personal data under GDPR. It must be explicit, and the user must make that positive affirmative action specific to the collection of that personal data. The second lawful basis for processing, and originally a lot of people think like, oh, consent, it's difficult. We're going to be missing out on a lot of data. And in the legislation, as you can see there in recital 47, the processing of personal data for direct marketing purposes may be regarded as and carried out for legitimate interest. So it's possible for marketing, advertising, you can use legitimate interest, so the legitimate interest of your organization, as your lawful basis for processing. In doing so, though, that does not give you carte blanche to all personal data, and you can just go about any type of that collection that you want. There are a number of different steps that need to be taken, a lot of different documentation and provisions that need to be really gone through in order to have a legal, legitimate interest reason for collecting that. The 3 elements here that it really boils down to are those different tests that you would need to go through. If you are stating that legitimate interest is the lawful basis for processing or collecting any of that personal information, you need to go through the purpose test, so identify what that interest is. Necessity test, show that whatever the business outcome is fully necessary to collect that personal data. And then you also need to perform a balance test. So balancing the risks to an individual and their privacy and identification with the business benefit that you're seeing as a result of being able to collect that. If you can pass all 3 of those tests, you can use this legitimate interest as your basis for processing. But again, it must be included in the details and the fact that you're doing so within that privacy notification. Also here, the right to object is absolute. So there must be that opt-out ability, and you must stop processing or collecting that data as soon as someone does object. 8 rights also laid out in GDPR for individuals. Let's quickly touch on these. Right to be informed, right of access, right of rectification, erasure, right to restrict processing, data portability or movement, right to object, and then rights in relation to automated decision-making and profiling. I wanted to highlight these just because they do fall in line. They're very similar with those rights that are afforded under the California legislation. So the right to be informed, user needs to know that collection processing is occurring, why, what platforms, all of that. User needs to have a right to access their personal information, erasing that, as well as that opt-out ability for any of that collection that's occurring. So that was a kind of a whirlwind on GDPR. I have done a number of webinars. We have a number of content on the website, much more in depth on GDPR. So if that is something that is of relevance and interest to your organization, definitely check out the Tag Inspector website. Quite a bit of additional content there, and everything that you would need to know for marketing advertising as it relates to GDPR. Finally, the third legal regulation that we're going to be talking about here today is the e-privacy directives, and what those are. So again, these are oftentimes referred to as cookie laws. They are in the EU, so there's a directive put out by the overall governing body of the EU, which basically is saying that it's extremely important for users to have a clear and comprehensive understanding when any activity that is resulting in storage of or gaining access of information about them is happening. So this would constitute cookies. You're placing some sort of identifier, you're placing some information in order to be able to be accessed later, and that's where this really falls in. Now, the one thing about the e-privacy directive is it is just a directive, so it's saying all of the member states need to do something about this, but at present, enforcement and the requirements fall down at the individual country level. So in Spain, the rules are a little bit different than the UK, where rules are a little bit different than Germany. So an important thing when it comes to e-privacy is understand for your business, where are your web properties, where is your audience, which of these really apply to you, if any, or if all, or specific sites and specific markets. And those different markets, those different countries are going to dictate what the requirements are. Now, for purposes of this, what I've put together is just kind of a summary of a few different markets to give you an idea of what the requirement is. Basically, the requirements under e-privacy are the ability, consent of placement of cookies and use of cookies by users, as well as just transparency and notification that cookies are in use and information is being stored. So UK, consent must be freely given, specific, and informed. So it must be an unambiguous positive action. It does not necessarily have to be explicit consent, but again, needs to be given by a clear positive action. This is interpreted differently by different legal teams, kind of depending on how conservative or liberal, I guess, with your policy that you want to be. So some people interpret unambiguous positive action as any actual activity of a user, as long as they're notified that this activity will result in the setting of cookies or the placement of cookies. And so that could be like a scroll, a click on a button. In some cases, I've even seen it just a user coming to a website is a positive action of consent because they're accessing that content. But again, in all of those different cases, that action that is resulting in the tags firing and cookies being set is specified. In Germany, consent is only necessary for non-pseudo-anonymized personal data, so if it's like clear text. But even for pseudo-anonymized personal data, like a client ID, cookie ID, users must have the ability to opt out. And a detailed cookie page must be available. So users must be able to see what platforms are loading, what cookies are they setting, how is that being used, and then again, the ability to opt out of each of those different options. Spain, consent to cookies can be implied as long as the user has been informed and is transparent about the use of the cookies. But again, must be a method of opting out. Sweden, consent can be communicated through browser settings. Information requirements still exist. So again, users must be notified and aware that cookies are being used. And then finally, last example I have here is France. This is much more closely aligned with the consent requirements under GDPR. Free, specific, informed consent must be given to set cookies. Must be a positive indication with the ability to not grant consent, and also must have the ability to opt out. There is an exception in the French law, though, and you'll see this across a few different markets, for anonymous analytics tracking. So as long as that tracking or the settings of those cookies, the use of the information that's being set is anonymous and aggregate at the end of the day, until a user grants consent for it not to be, that is allowed under that French legislation. That does not apply, though, to if you're using like media tagging or media platforms for purposes of audience creation. That would not be anonymous and aggregate. So it would require consent for those tags to execute and those cookies to be set. So that's a lot of different regulations, a lot of different rules that are defining the game that we need to play when it comes to managing tags, setting our tag governance policy, and those different requirements that we need to keep in mind. So what are the requirements for your business? What should you be doing today in order to be able to make sure that you are engaging in compliant data collection? First one is, and it's true of all of these different pieces of legislation, you need to understand all of the different platforms that are loading on your website. You need to understand how they're getting there, where they are, what data is being collected, because without understanding what platforms are collecting information and what data is being collected, and if cookies are being set, you can't make that determination if any of those data points are personal information under the California law, personal data under GDPR, or again, if they're setting any type of cookies or identifiers, and what the purpose of that is under the privacy regulations. So step one is do a tag audit. Understand the different tags that are loading, the platforms that are loading, where that data is going. This here is a screenshot from our tag inspector tool that shows, just for a given website, all the different platforms that are loading, as well as how they're getting there. The scary thing is, for so many organizations, this is the reality, where you have tags that are piggybacking or loading through other platforms. So you as the organization, as the end client or the end website, you have very little or no visibility into what those platforms are, that behavior is even happening. And that's where that audit really comes into play, and why it's so important. Understand what's happening on your website first, and then we can start working through the process to making sure that all that activity is compliant. In terms of the steps that you really need to go through, questions you need to ask when it comes to, again, compliant data collection. Number one, like I just mentioned, understand all the digital platforms and the tags that are executing and loading on your websites. That's the tags that you're directly managing through the source of your page, through a tag management system, as well as anything that's piggybacking or loading through other third parties that you might have loading. Because at the end of the day, it's you, the end organization, that's going to be responsible for those. For each of the different platforms, ask yourself what data is collected. And then for each of those, in terms of the data that is collected, does it fall under those definitions of personal data or personal information for the applicable legislation? If it is personal data under GDPR, we need to start going through the steps to make sure that it is compliant. So what is our legal basis for processing? If it is consent, are all of the, is my consent mechanism compliant? Do I have records of consent? Kind of on down the line, is all of that reflected in my privacy notice, all that? If it is legitimate interest for each of those platforms, have I gone through that necessity test, the balancing act, or the balance test, all of those different things, and do I have it documented? That's really the key, especially when it comes to GDPR, having a defensible position if a question is ever raised or if an issue is ever highlighted on your website. If you are collecting personal information under what would be defined as personal information under the California law, what are those categories? Again, going back to, we went through the different relevant categories. So what are the categories of personal information being collected? For what purpose is the personal information being collected across each of the different platforms? With whom is it shared? What other platforms is that information being shared with? How are you using it downstream? And then are proper disclosures out there for a user, and do my consumers have the ability to opt out? Is that mechanism compliant? Finally, that just covers the data collected by the tags. Neither one of those legislations really speak directly to cookies. They don't care what's stored on the client side. It's all about what's collected, what's processed, how it's used. But then with the privacy legislation, we get into what cookies are being set by each platform. Is proper consent or notification being made of such behavior? Again, country specific, market specific. It's going to depend entirely on who your audience is and where you're running and managing those different web properties. And then finally, do users have the ability to opt out? For opt out, it would be a good idea to make that just uniformly compliant or applicable for the California law, for GDPR, for e-privacy. Just to make it a little bit easier on yourself. Same thing with any type of disclosure to the user. So maybe banners that you might be using, notifying the user of the collection of that information, as well as your privacy notice. Making sure that all of these different legislations are covered is going to be key. So to help with managing this process, as shown before, tag audit, super helpful. These are just, I'm going to show a couple of reports for how I have helped different clients in the past and different partners in the past really walk through these types of processes. So starting out, just high level inventory, what are all those different platforms that are loading on my website? How are they getting there? What does coverage look like? So how prevalent are they across different pages? And then really going through the internal work to assign a business owner to each of the different platforms, understand are these tags, were they requested by, or are they managed by a different agency partner or an external person? Do I have legal approval, security approval? And then start making some determinations. Is this something that I should have on my website? Do I want to keep it? Do I want to move it, change how it's managed? To really shore up, one, that policy, and also your overall tag architecture. Now, taking this one step forward, we can take those questions that we were asking ourselves about, compliance with the different legislations and start walking through a similar audit process for each. So with GDPR, again, for each of the different tags and platforms loading, are they loading personal data? If so, what? What is my legal basis for processing those pieces of personal data? Is all the documentation in place? Have I gone through all those exercises? Same thing with consent. Making sure that I have a proper consent mechanism and record, and then making sure that everything is updated and reflected in my privacy notice with a transparency requirement, and then seeing if there's any documentation around compliance or data sharing agreements that are in place. Same type of processes also for the CCPA as well as e-privacy. Again, looking at the specifics and the specific requirements for each of those. But going through this audit, really stepping through the data after you understand what is loading, is going to be critical. It's going to, one, inform your tag policy moving forward, and really help with cleanup. Next piece here, that we know what the requirements, some tips, tricks for optimizing compliant data collection. And we're kind of running out of time, so we'll quickly go through these. First one is going to be consent considerations. If it's necessary to have consent, making sure that consent experience, user experience, is optimal. Data is extremely important to understand the effectiveness of different marketing initiatives, as well as to build audiences for advertising, understand the effectiveness of advertising. It's critical. Analytics. We need to make sure that we are getting as many users to consent as we can. So making sure that experience is optimal, and really encouraging people to do so. Next thing around tag management process and policy, making sure that you have a tag management process and policy. There's ownership There are people that are responsible for these different platforms. Getting that in line so that nothing hops up or pops up on your website that you're unaware of, putting you out of compliance. Along those lines, that central ownership of tag management, you can't have a bunch of different hands in the cookie jar. If you start releasing ownership and letting a lot of different partners and different players implement their own tags, that's when you really run into trouble with unauthorized tags showing up and things that are uncompliant starting to happen on the website. Utilization of a central data object. So if you're not using a data layer, just from a pure simplicity and cleanliness of data standpoint, when it comes to the data collection architecture, it can also have a great impact on governance. If all the different tags are required to reference just your data layer object, you can obviously control what data is being placed there, the format of it, and you can really clamp down on some of those privacy concerns as well. Accountability, again, have ownership of the different platforms, make your different partners and the different people that you're working with accountable for the platforms and the tags that they're managing. And then also ongoing monitoring. So having some processes in place in order to be able to make sure that the architecture stays solid. This is just a quick screenshot of policy, a whitelist policy, defining the different things that are allowed, and then having a system in place. This is using Tag Inspector, but there's a number of ways you could potentially do this within your organization, making sure that no unauthorized platforms are popping up, no unauthorized data begins to be collected. The final thing I'll mention here in the last few minutes are those ITP considerations. So just kind of throwing it all out there. ITP considerations are important because, again, there's starting to be technical responses to privacy concerns. So ITP is intelligent tracking prevention. So it's an initiative that Apple is rolling out within Safari browsers on both mobile and desktop. If your organization has a large proportion of users using Apple devices or accessing your websites and mobile apps with Safari, you're going to be more largely, I guess, impacted by this. So the current iteration is ITP 2.0. Basically, it just put close to an end to third-party cross-site tracking. So what it does is it'll partition third-party cookies and then delete them after a time. So the response was to start transferring third-party cookies and begin setting them as first-party cookies. If you're using GTM, for example, you probably were notified that you need to start using the conversion linker tag in GTM for any like Google Ads, or migrating to using the G tag, which has that technology just kind of wrapped up in it. So in response to that, a new update, which is in beta right now, will be rolling out here pretty soon. Basically sets new restrictions even on first-party cookies. All cookies set by JavaScript on a website are going to have a 7-day expiration. That's going to have an impact on analytics, because if I'm a user, come to a website, and then I don't return for 10 days, I'm going to be registered as a new user at that point in those 10 days. Whereas now, you can customize it in many different scenarios, but a user is going to persist. So even if I come back to your website a couple months later, I'm still going to show up as a return user. So there's going to have a lot of implications here and what it means for your organization. Again, it's going to limit cross-site tracking capabilities, already very limited, but that's going to have an impact on some of the different technology vendors that you might be working with. So I would ask what people are doing to combat this. Just to make sure that you get the same level of service, as well as you can maintain the same expectations for those different marketing technology platforms. But it's also going to limit that first-party cookies to the 7-day expiry. So there are some potential workarounds that are being thrown around, such as using local storage and some other approaches. But for all of those, we're only delaying the inevitable. So any workarounds, just like how the workarounds were, change things from third party to first party, there's been a fix that went in place. So it's going to be good to start thinking about privacy first and respecting the rights of privacy of the different users. So changes to goals, changes to how you're measuring things, and potentially really putting a highlighted importance of subscription and logging in. If when a user logs in, obviously, you have a user ID that can be associated with that user. So it's going to be much easier to maintain that relationship and that visibility for those users and maintain that data collection for users under that scenario. So with that, I know we are at 2 o'clock. So yeah, thank you everyone. Stick around for a few minutes if anyone has any questions at all. We will be sending out the slides to everyone that's registered and attended. And as always, if you have questions, please reach out to us, reach out to me directly, reach out to us through the Tag Inspector website. Happy to answer any questions about compliant data collection and be able to walk you through any of these processes if you're really thinking that you need to go through that tag audits, creation of a tag governance policy, as well as the ongoing monitoring of that.